By calling roll. Oh, there we go. We got the mic. There. Okay. Vice Chairman Jeff Nelson, I believe, will be joining us a little late tonight. Secretary Jay Lusky.
Present.
Member Brian Patterson.
Present.
Member Linda Grice.
Present.
Member Clay Alsop.
Present.
Member Joanna Condi.
Present.
And alternate member John Albright. Present. Okay. Looks good. We will get the meeting started by reading an opening statement. This commission is composed of Peoria citizens who have been appointed by the City Council to serve on the commission as civic responsibility without compensation. Our duty is to study and review planning and zoning issues within the City of Peoria. The commission hears zoning cases, holds public hearings, or may conduct a study session on a topic. Decisions are made by the Commission are forwarded as written recommendations to the City Council, who take the final action. All hearings are conducted in accordance with rules for procedures and Robert's Rules of Order. Each case will be called in the order at which it appears on the agenda unless otherwise announced during the meeting. In the interest of maintaining a fair and efficient hearing, the Commission adheres to the following steps. The Chair will open the case. City staff will then provide a brief report and recommendation. The applicant is then invited to give a presentation. Then any member of the public may provide testimony. The testimony is limited to 3 minutes. When we call your name, please come up to the podium and provide your name and address. After all of the testimony has been taken, we will invite the applicant back up to provide any rebuttal or final statements. Finally, we will have the Commission discuss and a decision will be made. Anyone wishing to speak must complete a speaker request form and hand it down to the assistant on my left, down at the end of the dais. Please be as brief as possible and don't repeat statements already made by others. Any member of the public may appeal to the City Council the decision of the Commission regarding a conditional use permit. The appeal must be submitted in writing to the Planning and Community Development Department within 15 calendar days of the date of the Commissioner's decision. All Commission recommendations on public hearing items include general plan amendments, rezones, zoning code amendments, and special plans move forward to a regular City Council meeting. The City Council will then act upon the recommendation of the Commission. The City Council may concur with the decision, modify it, overturn it, or remand it back to the Commission for further consideration. We welcome citizens' comments, and as fellow citizens of Peoria, we thank you in advance for your cooperation. Okay, that being said, I'm going to call for the final call to submit your speaker request forms. Again, please fill them out and turn them in at the end of the dais. First up on the agenda tonight is the consent agenda. We have 2 items tonight on the consent agenda. That is item 1C, disposition of absence, discussion, and possible action to approve and or excuse the absence of Commissioner Joanna Condi from the Planning and Zoning Commission meeting held on January 4th, 2018. And then item 2C, the minutes, discussion and possible action to approve the minutes of the Planning and Zoning Commission meeting held on January 4th of 2016. Do I have a motion on the consent agenda?
I'll make a motion to.
Okay, moved by Commissioner Lusky.
Second.
Seconded by Commissioner Alsop. Would you all please vote? Okay, the consent agenda passes unanimously. We'll move on to new business. First up is we have item 3R. That's Z1730, Life in Christ Lutheran Church initial zoning. A request by the City of Peoria to apply initial zoning of a suburban ranch, SR 43, to a newly annexed property comprising 2.19 acres located at the northwest corner of 75th Avenue and Bannock Lane. The SR 43 zoning district is the closest associated zoning district to the prior Maricopa County Rural Residential RU 43 zoning district. I believe staff has a report. Sean, you're up.
Mr. Chair, thank you, members of the Commission. My name is Sean Allen, City Senior Planner with the Planning Division. Good evening. This property is located north of Thunderbird Road along 75th Avenue and on the northwest corner of Banff and 75th Avenue. As presented, it's 2.19 acres, and the request is for initial zoning for Maricopa County, rural residential RU 43 to the City of Peoria Suburban Ranch SR 43. The current uses on the property are worship services and religious-related activities, and there's proposed no change to that. Surrounding the property to the north is single-family residential subdivision that's within the city. Also to the east, but to the west and the south is single-family residential that's within the county. A little background on this property. The city required the Life in Christ Lutheran Church ownership to complete the annexation process as part of an agreement that allowed the church to connect to the city utilities. They complied with that and submitted their annexation request, and the annexation of that property was approved and adopted into the City of Peoria on September 25th, 2017 by the City Council. State statute requires that the city assign an initial zoning within the first 6 months of that effective date of the annexation. And per state statute, the initial zoning shall not permit uses that are more intense than those permitted by the county prior to that annexation. Key findings, the property was annexed into the Peoria jurisdiction effective October 26th of 2017. The recommended suburban ranch SR 43 zoning district is the closest corresponding zone to that county RU 43 zone that's currently assigned to the property. The timing within that first 6 months and this zoning recommendation are in compliance with the Arizona State statute for the initial zoning request. And the city has not received any opposition from the general public so far. Our recommendation is to approve case Z1730 to the City Council. With that, open it up for any questions that you may have.
Are there any questions of staff before we open the public hearing? Still no, there was no opposition to this? Any traffic concerns?
No word at all from anybody, Mr. Chair.
Okay. All right, seeing no request to speak, I'm going to open the public hearing. Is the applicant present? No applicant? And I have no speaker requests.
Mr. Chair, the city is the applicant.
I'm sorry?
The city is the applicant.
Okay. Oh, yeah, I guess that would be. Is there any further discussion on this topic? Any questions from the commission? Okay, seeing none, I'm going to close the public hearing. And we will have final comments if there are any. It doesn't look like we have anything. Okay, seeing no comments and no questions, I will accept a motion on item, sorry, item 3R. Commissioner Condi.
Move to approve?
Okay. We have a motion to recommend a favorable recommendation to the City Council of Z1730. Do we have a second on that?
Second.
All right, second by Commissioner Patterson. Please vote on the motion. Okay, and it passes unanimously. Okay, next one up is item 4R, Z17-11, 99th Avenue Estates rezoning. A request to rezone 2.25 acres from general agricultural to single-family residential R1-10 for the future infill development of 6 residential lots located north of the northeast corner of 99th Avenue in Hedgehog Place. I believe we have a staff report.
Yes, thank you,
Who's up?
Mr. Chair,
Sean again.
members of the commission. This subject property, as you can see from the map, is located north of Joe Max, west of Lake Pleasant Parkway, and it's just north of the northeast corner of Hedgehog and 99th Avenue. The property is just 2.25 acres, And the request is to change the zone from the general agricultural AG to a single-family residential R110. The current land use designation is low-density residential, which is a 2 to 5 dwelling units per acre with a target of 3 dwelling units per acre. And all the properties to the north, southeast, and west share this same land use designation. The site is currently zoned, as we said before, the general agricultural. This is a holding type zone until the development typically comes in. The surrounding zoning districts to the north, south, and east are all part of the Pleasant Valley Residential Planned Area Development, which is a PAD that's a custom zone that has development standards that are modeled after the R110 and R112 zoning districts. To the west, across 99th Avenue, is the Tierra del Rio Residential PAD. And that PAD is characterized by both single-family and multifamily units within that development. Summary of the rezoning request, again, is to change from general agricultural to the single-family R110 zone. The minimum development standards is listed in the table there. As a comparison, I gave you the R112 standards as well as at the right of, at the very far right column. And as you can see, all the standards pretty much match up except for lot coverage and then because of the size of the Pleasant Valley subdivision development, our standards require usable open space due to the number of lots that are associated with that. Anything that's 10 lots or less, they don't have to do that open space. Summary of the development is, again, it's 6 lots. The average overall for the development is a lot size of 10,400 square feet. Definitely designed to blend into the community or the neighborhood. It's a city standard street width and cul-de-sac. And then at the front, there's going to be some large landscape tracks with a monument identifying the subdivision and a matching wall. There's a nice decorative wall that goes along 99th on that east side for Pleasant Valley, and this developer's agreed to match that wall for their development. The noticing requirements require the city to send out a notice of application as well as a notice of hearing postcard. That was done for residents within a 600-foot radius, and then for all homeowners associations within a mile. The site was also posted by the applicant according to the city requirements. There was no, basically no opposition or no word at all from the general public regarding this proposal. They did have a neighborhood meeting that was held on December 6, 2017 at the Cross of Glory Lutheran Church, and Councilmember Binsbacher and just 5 members of the general public were there, and they all happened to be residents that either were adjacent to or near this property. And no one voiced any opposition in that meeting. Looking at the findings, the overall density of this proposal is 2.67 dwelling units per acre, which is consistent with the current general plan land use designation for low density residential. The proposal is in conformance with the goals, objectives, and policies set forth in the City of Peoria General Plan for an infill single-family residential development. The request for the R110 zoning closely matches the surrounding residential developments, which are also based on an R110 and R112 zoning designation. And then all public notification and outreach requirements were met, and the city, again, had received no opposition from the public. Staff recommends that the Commission approve case Z-1711 to the City Council, subject to the conditions outlined in the staff report. Open it up for any questions.
Thank you very much, Sean. I had a couple of questions about the report. The first one, can you explain, what's Prop 207?
Oh,
It just says that, and it doesn't give an explanation.
Mr. Chair, what Prop 207 is it's a waiver so that if there was a protest that arose due to the development of the property, they waive their right to that protest.
Okay.
Mr. Chairman, just a little bit of background. Prop 207 was a proposition that was passed by the voters back in, I think it was 2006. And really what it does is it allows property owners a legal right to, I guess, litigation, for lack of a better word, should a city action diminish the property value of their property. So if the city were to rezone a property, taking action, and that proved to diminish the property value, that owner would be entitled to compensation. So a Prop 207 waiver is a document we provide to the applicant. They sign and notarize, basically saying we're asking for the city to take this action on the property, and therefore we're waiving our rights to the litigation.
Oh, okay. And then there was a concern brought up, and I'm sure engineering will take care of whatever the issue was, but there was a concern about drainage that was brought up by one of the neighbors. I mean, I'm sure that there still needs to be civil engineering happening and.
Mr. Chair, yeah, they are addressing that through the preliminary plat, and then there also will be the final plat stage.
My apologies, the microphone was off. What I was saying is that there's a preliminary plat that's actually running concurrent with this application for the zoning, and they're looking at that closely. That's actually why you have those extra large tracks at the front. Those are acting as retention basins to address the drainage. Okay. They'll also have a chance to address that further at the final plat review stage.
Great.
So.
Okay. Are there any questions from the commission? Okay. With that, I'll open the public hearing. Is there anybody who would like to speak on this item? My queue is clear, and there's no one at the podium. We'll go ahead and close the public hearing then. Get to hear the gavel a lot tonight. Any final questions or comments about the project? Frankly, it really looks great. It looks like the neighbors are really happy with it, so it's a nice project. So I'm glad to see. Any other comments? Okay, with that, we'll accept the motion on item 4R. Commissioner Alsop.
I motion to approve item 4R.
Okay, we have a motion on Z17-11. Do I have a second?
Second.
Seconded by Commissioner Patterson. Without further discussion, let's go ahead and vote. Okay, passes unanimously. Okay. Next up on the agenda tonight is a study session, and we are going to go ahead and let staff give a report on this. These items, the study session for Z16-0013, the Cowtown rezoning. It's a request to consider a request to rezone approximately 78 acres from special use permit and floodplain to Cowtown planned area development to clarify the allowed uses, development standards, and operational criteria for the Cowtown range. This item is for discussion only. No action will be taken on this item tonight, but we will accept public comment when the time is right. Okay, so that being said, I believe Lori, you're up.
Thank you, Chairman, members of the Commission. My name is Lori Deaver. I am also with the Planning Division, and I have the pleasure tonight of presenting this study session item to you. Again, this is for discussion only. Because of the complexity of the case, I'm going to be outlining the project details and answering any questions that you may have this evening. So with that, let's begin. So a little bit of background on this particular one. Cowtown has been in existence for quite some time. So this isn't necessarily a typical rezoning case. It has been in existence since the 1970s through the county into the city of Peoria. What we are doing tonight is reviewing the rezoning request, which is to rezone to PAD. That is to clarify the uses that are allowed on Cowtown, the development standards associated with it, and the operational criteria for it. This evening, the applicant is here if you wish to have any questions of them. Brian Greathouse is representing Westward Ho Adventures. Cowtown is approximately 78 acres in size. It is in the northern area of Peoria. It is off of Lake Pleasant Parkway via the Old Carefree Highway. And as you can see, there's a couple of master plan communities in the area over to the west. They are at a minimum of 1 mile away. That would be with Lake Pleasant Heights. Adjacent uses. To the north, and almost everywhere around it, is Arizona State Trust land. And that is managed by the Arizona State Land Department, ASLD. You will be hearing about that a little bit tonight. So when I use the acronym ASLD, that would be the Arizona State Land Department. They've also provided a letter, which I'll go and talk about later on. So Arizona State Trust land is surrounding the property. To the east, immediately bordering the property, is the Agua Fria Wash. You have about a 420-acre undeveloped vacant piece of property. You also have Canyon Speedway in there, and slightly off the map, you have Turf Soaring School. Both Canyon Speedway and Turf Soaring School are leased land from ASLD. This part, I'm going to go into a little bit of detail, historical context, and it is important with regard to why we're actually here talking about this project tonight and the unique conditions surrounding it. As I mentioned, this is started in the 1970s. The property was purchased in 1974 by Ron Nix, and he developed it through Maricopa County. His intent was to develop it as a venue for outdoor entertainment activities oriented towards the Old West and film productions. He was a Hollywood stuntman at the time, so that's where the correlation comes into. The current ownership took possession of the property in about 1993. Why is that important? That was shortly before annexation into the city of Peoria, and I'll talk about that relationship a little bit later on. But after the ownership changed from Mr. Nix to Westward Ho, right now, they introduced firearm training and marksmanship classes. So this was occurring through the county prior to annexation. So Mr. Nix went through the Maricopa County approval process as he had the vision for like a rawhide or a tombstone, or kind of like the Wild West theme. He received a special use permit for an amusement park. Later on, that entitlement, that special use permit, was adjusted to allow sand and gravel operations within the Wash Corridor area. That was later abandoned, and those no longer occur within the Wash Corridor. He also added 3 additional movie sets, so there was an adjustment to the special use to allow 3 additional movie sets. Those are currently in use today. As I said, in 1993, the ownership changed. The property was annexed in 1994, and it was part of a regional annexation plan. So as you can see on the screen and in the graphic, from 1954 to 1990, the city added 62 square miles to their landmass. In the 1990s, the development picked up, and the term, the race to the lake, was kind of coined at that point in time. Now, at that time, Cowtown was an asset in order to make that race to the lake happen. So they were kind of a linchpin, if you will, for the lighter blue portion of the property. Now, because of that, because the city approached Cowtown and they asked to be annexing them into the city, the property owner, Westward Ho Adventures, asked, he was willing to be annexed into the city, so long as the existing land uses that were occurring on the property be recognized and grandfathered. Why is that important? I will talk about this a little bit later, but within your packet, you have a letter from the then Peoria City Manager, Peter Harvey. What Mr. Harvey did was to identify the types of uses and, to the extent, recognize the uses as was part of the agreement between the city and the applicant. So I will go into that a little bit further later. From the general plan standpoint, the land use category hasn't changed. It's always been park open space and estate density residential. And the reason why the designation never changed is because Cowtown is considered a private outdoor recreation facility. And that would be analogous to the park and open space designation. So it is compatible with the Peoria general plan. It's never had to be changed, the land use designation. The zoning, kind of as we were tonight, kind of assigning initial zoning or making a recommendation for initial zoning, that occurred in 1994. Now, the closest zoning districts at the time within the city was special use, SU, and floodplain districts. And that is important because later on, after the property received zoning, the floodplain zoning district was removed from the zoning ordinance. So if the applicant had wanted to make any changes, they could not use the floodplain designation to continue forward. It's basically, it's gone out of the ordinance, and they would be non-conforming, I think is the most appropriate term. So they would not be able to make the improvements if they choose to. And so that's why one of the recommendations we asked for them to consider was the planned area development, or PAD option, because that could specialize the development standards, and it most closely aligned with what the intent was when it was SU and FP. So that's kind of the most closest mechanism we could get to them. So that's why we suggested that route. So let's talk land use, because this is a unique property and a unique set of land uses. Cowtown has been a host of an array of recreational amenities and activities since the 1970s. And they've included shooting competition, firearm training classes, advanced training. They've had movies, film productions, television productions out there. You name it, it's a wide array. Now, the uses continued. Those uses have continued on the property in some form since the 1970s. However, those uses weren't clearly defined in Mr. Harvey's letter. That was the best instrument at the time that we had to be able to identify those uses. But let me give you a couple of examples in terms of why it doesn't necessarily work for us right now. So the letter identifies paintball, sporting clays, and training activities. So let's focus on the term training activities. I'm sure all of you, when you said that, had something pop into your mind, what a training activity is. And I bet if I took a poll, all six of you would probably have a different opinion as to what a training activity would be. So it creates some ambiguity in that regard. So if you think it's difficult for 6 people, we as a city are a little bit larger staff, it gets a little more complicated at that point. The next one, cookouts, gatherings, and dances. So let me ask you these 2 questions. Cookouts. Does a cookout mean camping? Does a dance mean a concert? Some of you might say yes, some of you might say no. So again, it's ambiguity. How does staff and how does the applicant make that interpretation? And so again, we believe the PAD option is the best option to solidify the uses that are going on out there right now. So let's get into one of the most unique options and land uses about the property. So while the city is the land use authority, staff recognizes that an outdoor shooting range is a non-traditional type of use. And the specific conditions and the special requirements associated with designing, maintaining, and operating such a use, that is outside kind of our realm. I'll tell you that as a planner, that's definitely not something that you would normally see within a zoning ordinance anywhere within the valley. So in terms of like what are the permitted conditions, how to operate it, that's definitely outside of our rule book on that one. So consequently, we asked and staff determined that those requirements, the operational management requirements regarding the shooting range and operations, that was best left to Cowtown's experience. They've been running this shooting range for a number of years. At the same time, they selected a consultant with expertise in designing and the management of the range. His information was provided within the staff report to you. He reviewed, the expert from hired by Cowtown reviewed the information provided to him. He did ask for certain modifications to the range to be made. Those were made. And he re-reviewed the information, and he has determined that they are now meeting best management practices. A couple of tidbits on this one. Arizona state regulations, we do not have regulations associated with running an outdoor shooting range. So there are no regulations for Arizona. Other states may have some, but we do not. The military has regulations. We do not. So we are relying on the expertise of the individual hired by Cowtown based on his credentials, which included management and operations of Ben Avery, which is located about 6 miles from Cowtown. So he is familiar with the terrain and the operations and the conditions out here, and has, again, certified that Cowtown meets best management practices. So going forward, the owner is going to be responsible for making appropriate modifications to ensure best practices are maintained. Why do we say that? Because the sport and shooting in general evolves. Best safety practices evolves based on the conditions, based on what's being used at the time. So things may change. We want them to continue to operate in the best manner possible. So that's the agreement between the city and the owner, that they will continue to look at best management practices and make accommodations and changes to what they're doing on the range to meet those standards. So, again, city is the land use authority, but this is not necessarily our expertise. So we are working collectively together regarding a memorandum of understanding. Some things are not necessarily the best left within the PAD. They're best in an agreement between the city and the owner. In this case, that is occurring. That will be going and presented for council for consideration as well. So some of the measures associated with the shooting range will be housed within the MOU rather than a PAD document. And I'll explain a little bit about that MOU in a little bit as well. So, as I mentioned, access. This is still a fairly rugged property. Lake Pleasant Parkway is the primary road to the site. It is accessed via Old Carefree Highway, so there's one way in, one way out, so to speak. Water and sewer, there is none on that one. However, water's brought in, portable toilets are brought in on an as-needed basis. Part of what is proposed within the PAD is we have established when additional storage capacity would be required and permanent facilities would need to be provided when any future enhancements to the property and expansion occurs. And the PAD allows for that enhancement and expansion at that point in time. On the public safety side, the PAD outlines when additional review criteria will be applicable. That comes into play, and I'll talk about that briefly with the letter or email that was provided to you from Arizona State Land Department this afternoon. The owner has agreed to fence and sign the entire property, And the post may be substituted based on field conditions and proximity to wildlife corridors. This is a very undulating territory. There are canyons, there are within it. We do want to allow wildlife to continue to go through those corridors, and so we are asking for fencing. There's a stipulation for fencing and post at an interval spacing signage, because this is a shooting range. Signage will now ring around the property saying, "Don't enter." And there's actually criteria that Don Turner has recommended, a specific sign to say, hey, this is more than just don't enter. This is like, hey, warning. So that's also there. Now, public outreach. The typical process is followed. We did the notice of application, and we did the notice of hearing. We held the open house, and we posted, and the sign was posted. Because of the location, only about 4 people were noticed, because there is no HOAs within a mile. It's basically state land, and there's only one property owner pretty much right next to it, so about 4 people were noticed. So we had no opposition to the request. We held the applicant held the neighborhood meeting November 7th, 2016 at the Wild Horse Restaurant. No opposition was received until the day of November 2nd. We received a letter of opposition from ASLD, and at that point in time, oh, hello. Not sure what's going on that one. That's a technical error, and I wasn't touching the mouse. I'll just have that noted for the record. So the case, we did ask, based on the discussion with State Land and the applicant, we asked that the case be continued to January 4th, 2018. Subsequent to that continuance, which was granted by the commission, both State Land and the applicant met and began actively working on the agreement to address the basically 3 areas of concerns outlined within that letter of opposition. During that time, as they were continuing working, January 4th was coming up. They were close, and so in the staff report, I noted that that ASLD and the applicant were continuing to work on the agreement. So we asked for a 1-month continuance. So you will see me in 2 weeks again presenting this, hopefully, at that point in time. Now, in all seriousness, the letter, which was provided to you this afternoon, attached to the memo, it basically outlines that ASLD is intending to withdraw their opposition based on adding provisions to the city's MOU that is with the applicant. In addition, it's upon the execution of the agreement between the applicant and ASLD. So they have their own separate agreement. So the city and the applicant have an MOU, if you will, an agreement that we are working on. The ASLD, State Land, and the applicant have their own separate agreement that they're working on. Hopefully I have not lost you. I have 2 attorneys in the room that I'm going to lean on, and again, one is in the back as the applicant, and who could probably more eloquently explain it than I can with all the details, should you wish to hear from them. So with that, oops, that's a lot of information on a very complex project, and so I will open it up for whatever questions you may have.
The whole thing just lit up. Before we get started, I'm gonna ask a question first, and I'm just out of my own curiosity. On what authority was the letter issued from the city manager? Was it by action of the council and mayor? Was it a commission that looked through the case? Who authorized the city manager to issue a letter like that in '94?
Mr. Chair, members of the commission, that letter was issued by the authority of the city manager during the annexation process.
Okay.
I don't believe it went to council.
So that would have been by authority of the council then?
Done by the authority of the city manager.
City manager?
Right.
So it went through no public process or public hearing or anything? It just,
I don't believe the letter went forward as part of the annexation case.
okay. I'll have other questions, but I do want to open it up for the rest of the commissioners here who want to weigh in. I have Commissioner Lewski.
A quick question or clarification, I think I understand, but to the west of Cowtown, I'm looking at Exhibit B, and it shows SR 43. The land from Lake Pleasant Heights all the way to Cowtown, is that all trust land? Or is there any developable land that could be
Yeah.
developed between there?
Chairman, Commission, yes, it would be ASLD land, so it is trust land from Cowtown to Lake Pleasant Heights. So a couple different things in terms of development opportunity. State trust land has the general plan designation over it. That general plan designation, because of the topography in the area, and I'm going to, please don't necessarily hold me to it because it varies depending on location. You will see a lot of park open space, you will see a lot of estate density residential, and you will see possibly low density residential. And those are the typical categories that you would normally find within that type of topography. So those designations would be consistent with what Lake Pleasant Heights would have been and consistent with the surrounding area of Cowtown.
Mr. Chair, members of the commission, I could also add too, so the property of Cowtown is about a mile and a half east of the Lake Pleasant Heights PCD, or the Planned Community District property. The intervening land, which is all the state land, and the eastern portion of Lake Pleasant Heights, as Lori mentioned, is very rugged terrain, so it's hillside areas.
Oh, yeah.
I think I erased everyone else that wanted to speak.
Okay, thanks.
If you guys could, if you want to speak, please indicate that on your thing. So while we're getting more of that, I went out there today, and I must say, that when I first learned of this, the activities that were happening and planned to happen, I was very concerned. I hadn't been out there prior, and I went out there today, and I drove around, walked around, looked around, and you know, there was some activity going on, and it was a lot more rugged than, you know, it's hard to see on the screen and on the packets that we get. So we went out there, and it was very, very steep cliffs and, you know, deep valleys and whatnot. It seemed like it would be a relatively safe environment to shoot firearms and have activities like that. I know in the presentation, it was indicated that a lot of the shooting was going to happen from the south toward the north, so north of, you know, northward shooting. I made some observations while I was out there today, and knowing the north to south trajectory of the whatever the firing is, and I don't know what I didn't see any limitations on the size of the ordnance. I saw 50 caliber for when the Blackhawks come in and shoot up a bunch of stuff. I guess that was part of this, but I didn't see any restrictions on the size of the ordnances being used. And I do know that there is a fairly large APS crew installing right now today a transmission line that runs east to west or west to east, or, you know, however you look at it, but just due north of the property. And I'm wondering if currently there's safety precautions being taken, knowing that their you know, guns are being fired in that direction, you know, line crews and whatnot working in that area right now. I'm just wondering about today's precautions and about future precautions, because we don't only have a lot of APS activity out there. The CAP, I talked to a lot of their employees as well, and, you know, and they, you know, obviously this thing has been going on for a long time, and it's been kind of quiet out there, and it's, you know, not really causing any disruption, but they were obviously concerned about, you know, current and maybe possibly future activities and the safety of their own crews that work on the CAP canal. I saw that the canal was quite a bit to the east. I do know it jets to the west a bit when it hits Waddell Dam as well, and I know they have crews constantly out there working on these projects. So I just basically what I'd like to hear is any kind of precautions being taken about, you know, notifying workers and crews and other activity out there about the potential for, you know, stray bullets here or there. I'm not a gun guy, but I mean, I like my gun. I don't shoot it a lot. So, but anyway, that being said, please, if anybody could speak to that.
Chairman, members of the commission, based on the information provided, there is a range fan study associated with this. It is not included within the PAD packet. that was prepared in consultation with Don Turner. I will also, if I defer to Brian Greathouse in the back in speaking about uses, just be prepared. But let me see if I can do the best that I can.
Okay.
Understand your concerns. In that range fan study, Mr. Turner looked at the caliber of the ammo. When each of the members goes out, they need to sign basically an agreement with the Cowtown operations, the management group. They have specific rules associated with each of the bays, platforms associated with it. You are correct, the maximum size caliber is 50. However, that is limited in certain areas at certain times, and so it is not on the entire range. The rest of it may be pistol shooting, it may be shotgun, it may be long range, and that caliber will be adjusted accordingly based on the information provided to the member. And so they are held to those standards within the information provided in the range fan study. So Mr. Turner has looked at that information, and based on the caliber, the backstops associated with it, or any other so you can use a number of backstops. You can use steel, you can use the berming in this case, which they do in the Bay Area. So he's looked at that information in terms of ricochet. So the information provided on there includes a surface danger zone, and it's basically a conical area in which, based on the firing line, where you would expect the shot to go and a possible ricochet to go, and so he has evaluated that. And I will allow Brian to speak further on that, but based on that information, and they have made additional adjustments, but the targets have been moved back away from the property lines to further ensure safety at that point. We are also, with regard to the APS concern, we believe the fencing around the property, the additional signage around the property will help basically alert others in the area. It's not so much as people wandering off of Cowtown, it's people wandering onto Cowtown that is more of the concern. And so that's where we think the fencing and the signage around the area will do. In terms of the helicopter shooting, couple of different things. The applicant, of points to make, the applicant will be submitting a temporary use permit, which goes through a city process each and every instance in which a helicopter operation will occur. That TUP application will include a safety plan and additional information that the police, the fire department, and any other departments who review that application will need to look at the application. Part of the information and the dialogue between both the state land, the city, and ourselves is Cowtown is responsible for maintaining operations on their property, and so that is that is part of their requirements, their performance measures, if you will, that have been included within the MOU, the PAD, and the agreement between state land and the applicant. So that's a long list. Hopefully, I've covered about everything on that one.
I think you did. All right. Well, thank you. Commissioner Condi.
I was out there yesterday, and I was really impressed. I must have spent 2 to 3 hours out there talking to people that ran the shooting ranges, and the fellow that stays on there, who's there, who lives there, and who monitors it. He's head of security. And, you know, I took my 2 dogs out, and I was really surprised that it was not as noisy as I thought it would be with all the shooting. They have places to stand, and it was, you know, so that they're shooting, and if the bullet goes astray, it hits an embankment which is crumbly, which absorbs all the bullets. I mean, it's because it is so rugged, it's not as if they're going to get bounced back. I thought that was impressive. They have different levels. He was telling me that they train snipers out there sometimes. They make an arrangement with the military, police come out. It seemed to me like they have no trespassing signs all over the place. If you don't have an appointment, you don't belong there. And I was really impressed with the thoughtfulness of all the people that I spoke with about safety issues. The other thing that we didn't mention is they have this, I guess, at one point in time, I saw this 25 years ago when it was active as thinking of movie studios. I guess since that time they had a fire and they have lost some of those old buildings that made up sort of a, quote, Main Street, an Old Town Main Street. And think they'd like to reconstruct them. That's kind of an interesting thing, too. I had forgotten how absolutely rugged the land is out there. It is not rolling hills. It is rugged from washes, and there's land barriers. You have to cross a bridge, and then you go on a dirt road, and when you get out there, you are in the middle. You feel like you're in the middle of nowhere. It's hard to believe that you are in Peoria. So I think, and you said that they had. Under best management practices, they are trying to be on top of everything as it comes up. Am I understanding that correctly? So I thought like you did, Sean, when I first went out there, I thought, oh, all this shooting is going to be really noisy. I can see all these problems. And I got out there and I was very pleasantly surprised. It's really a piece of the Old West, and it's a place where people can go and shoot safely. And they have training classes, and they also have very big competitions where people come out. So I think it brings people into Peoria for that purpose. And I don't know, I thought it's sort of a destination place in its own way.
Okay, great. Commissioner Albright.
Yes, thank you. You mentioned something about use permits, and I remember reading through that there would be temporary use permits. And can you explain a little bit maybe about, for me, what the frequency of those could be? Is there a limit to those throughout the year? You'd have them, I suppose, for the dances and the things that you might want to have there.
Chairman, Commissioner Albright, it's a good question. In certain conditions, a temporary use permit would be required. The PAD modifies, typically a TUP temporary use permit may be required up to 4 times a year, depending on the type of use. In this instance, the modification in the PAD allows a temporary use permit to be required every time an event that includes a generator, a canopy, or something that the fire department would need to look at. So if the type of event would have a fire outside of certain designated areas on the site plan, if it has a generator, if it has canopies, if they have certain demolitions going on, they would need to obtain a temporary use permit for each and every occurrence. There is no restriction on it. It's just the ability for staff to have an advanced level of review based on the conditions being provided.
If I could follow up with that just a bit, what would be the length of time for a permit, or would it vary depending on the use of that?
Commissioner Albright, it would vary based on the time of the event. For instance, if it was a camping type situation that may occur, or they've asked for something like a Tough Mudder or something, that may extend into multiple days. So the temporary use permit may extend over a couple of days. If it would be for, say, a demolition or something of that nature, those go pretty quickly. So that would be for a very short amount of time on that one.
Okay, Commissioner Alsop?
Yeah, I wanted to add in, I appreciate that the city acknowledges, I don't know that any of us are experts on gun ranges. Maybe, we lost our commissioner that was, but that they hired an expert, and that they've worked with them, and they've made changes that were necessary. I don't even know that I would understand what necessary changes would be made, but I appreciate that that's been done. And also, I have experience with the State Land Department, and they have also said that we're working on an agreement, and that they are consenting to no longer. They're not denying it, but asking that we deny it. And I appreciate that the state has no incentive except to preserve the value of the land, and if they're okay with it, and that weighs heavily on me, that we have experts who are hired to do something that maybe we weren't qualified to do. And the State Land Department, which is the neighbor, has also consented. So I wanted to just state my opinion that it sounds like they're doing their part, and I appreciate hearing from somebody who evaluated that and who has a past and experience in that.
Okay, seeing no other requests to speak, we all spoken for. Would the applicant like to say a few words?
My name is Brian Greathouse, 702 East Osborne Road. A lot of people deserve a pat on the back for this PAD, and I'm not one of them. Lori's been working on this since 2013, she told me earlier today, and I think Chris and Adam, I'm pretty sure, didn't have any gray hair when you guys started working on this in about 2011. So a lot of people have been working on this for a long time, including my client. One of the guys who is listed on that 1994 letter is Chris Shaw, and Chris Shaw is one of the Shaws that I work with on this property and this rezoning case. And then another gentleman is Ed Bull, who has been the managing partner at our firm for 17 years, and he's been at our firm for 35, 36 years. So he's been involved with this site for a very, very long time, so we have a lot of institutional knowledge on it. And it's a shooting facility, and they provide recreational shooting opportunities and competitions for private members. It's not open to the public. So it's private membership. It's very controlled and regulated. We have military organizations that come out there periodically and rent out the facility and train. There's a high need for these type of facilities across the country, and there's not a whole lot of them out there. To add to Lori's discussion earlier about the list in those letter, the permitted uses list, those aren't the list of uses that are permitted. They are illustrative of the type of uses that are permitted on the property. So that even confuses things even more than, as Lori was discussing earlier, you can't just look at that specific use, but you have to look at the character and type of uses that were intended by that list. So this PAD helps define a lot more of those things because it's exhaustive. When we put down a whole bunch of list of permitted uses, we have lists of permitted uses with specific conditions. We have temporary use permit uses, and so it's quite complex now in the PAD with rules and guidelines that are to be followed on the property, not only in the PAD but in the operations manual and handbook that is also going to be on file with the city so that everybody can go to the file and figure out what the rules are rather than somebody on the property trying to make up the rules as we go, or the city maybe not treating the property owner fairly when they're trying to do certain things on the property. It's a much, much better situation. And normally a zoning case is, or a rezoning case is, you're thinking about what the property is zoned today and you're thinking about what's being requested, and you have to, part of your decision is this a good use for the property? This case in 2 weeks when you vote on it will be, if you vote yes, you're voting for more regulations in the form of a PUD on the property, and if you vote no, it just means the site will continue to operate as an outdoor shooting facility with less rules that are documented in the PAD. So either way, the use will continue on the property. I think the PAD is a lot better for the city and its citizens and everybody involved for this particular use. That's my practical way of looking at it, rather than thinking we're rezoning from SU and FP to PAD, which is a little bit more technical. With that, I'm here for any questions. You guys had great questions earlier, and thank you.
Any commissioners have any questions for the applicant? All right, seeing none, that's it.
Thank you.
Good presentation. Well, that being the presentation, is there any other further discussion on this case? I know we are looking to have this on the agenda for
The next planning commission meeting, that's the February 1st, I believe.
February 1st. Okay,
Yep.
excellent. Okay, then we will move on to one of our favorite discussion topics, study session for TA 16-0001, sign code modernization project. Modernization project. Request to consider a city-initiated proposal to replace the sign code by amending sections 21-827 through 21-855 of the city code, recently renumbered from Article 1434 signs of the zoning ordinance. This item is for discussion only, and no action will be taken at this time. Who's up? Lori again.
Yes, I have the double header on study sessions this evening. All right, so. I will do that, yes. I do speak softly and carry a large zoning ordinance, so no, I'm joking. Yes, please let me know if you can't hear me. So let's completely switch gears now and talk signs. TA 16-0001 is a city-initiated text amendment known as the Sign Code Modernization Project. Easier said than done. I just call it the Sign Code Text Amendment, if you will. So let's talk, what is a sign code? It's basically a certain portion within the zoning ordinance. It's solely, the sole purpose of it is to regulate all sign types within the city. The screen on, the graphic on the screen right there is just an illustration of what the number of sign types you could have for like a commercial business. And so when we talk sign types, there is a fair number of sign types as we go through this exercise. So it is a comprehensive rewrite from start to finish of the sign code. Tonight I'm going to give you a little bit of background about the project, also some refinements and recommendations that have been made since the last study session on that one. So let's get started. Two important reasons why we are undergoing this process. The first one that I'm going to talk about this evening is the 2015 Supreme Court decision, which was basically Reed versus the town of Gilbert. The graphic that you see on the right is an illustration to look at. Now, the town of Gilbert at that time regulated their temporary signs, if you will, the little A-frames or things that you would see in the yard. They based it on the message content. So looking at the graphic, a homeowner's sign could have the sign area as large as what would be the blue square. The political sign would be something like in the purple square, and the church our ideological sign could have something in the yellow square, if you will, and it goes on from there. So you had to read the sign in order to know the amount of area that you would get for that sign. When it went to the Supreme Court, it was unanimous, a 9-0 decision, which is sometimes fairly unusual, but it was a unanimous decision against the town of Gilbert on that one, and they reversed a lower court ruling. What they said was content neutrality is key. You cannot read the sign in order to enforce the code. So that is the mantra going forward with this modernization project. We're not reading the sign to know how to enforce the code. Now, while it was a unanimous decision, there was a majority opinion and 4 additional opinions associated with it. In that context, they opined that there was ample content-neutral options that the city can use or municipalities can use to regulate signage. We can look at safety, aesthetics, size, building materials, lighting, moving parts, and portability. And that's not an exhaustive list, that's just an illustrative list in that regard. The other primary reason that we're doing this, and he's not here, so I'm picking on him. Not comprehensively updated since 1989. Our director had a little bit more hair along with everybody else with the 90s. Our phones were much larger. They were not as smart. If you can think of all the hairbands associated with that. Good for you. We have some outdated terminology within the code, some things that the industry just doesn't call them anymore. And we, like I said, our signs are not, our standards are not content neutral. There's 2 illustrations on that slide right there. How do you know it's a menu board unless you read it and understand that it's a menu that you're looking at? How do you know that it's a sell, lease, or for rent sign unless you read the sign and you know it's for sale? So that's not content neutral in any regard. Also, we have 2 very lovely examples on that screen of 48 pages long worth of text-heavy code. 48 pages of that, very few pictures, and on top of that, we have a large number of sign types. So we have a great opportunity here to do something bigger, better, and easier to read, for sure. So the goals, primary one, achieve compliance with the Supreme Court decision. Second one, for everybody, increase the ease of use for all users. We have a wide range of people that we talk to on a daily basis. It could be somebody starting a new business. It could be somebody who's been in the business for a while. It could be a mom and pop that's coming in, property owner, wanting to know what to do. It could be an industry representative. So the code that we're trying to put together needs to be able to speak to everybody that we interact with on a daily basis. At the same time, we're balancing a couple different hats. We want to be respectful of the businesses and of the property owners' rights at the same time. So we're balancing neighborhood issues, we're balancing citizens' issues, we're balancing business issues and concerns. And so we're trying to provide standards that create a functional and an aesthetically appealing environment as we go forward. Now, I'm not doing this alone. This is a very large team. And I got to give a shout out because she probably will be watching from afar. Melissa Sigmund was the project manager. Although she's in North Carolina, we won't hold that against her. She's done this a couple times, but she's been the point person on this one since the start in 2016. I've had the pleasure of going kind of behind the scenes and working on the graphics and some of the editing from the start. So that's just 2 of us, but there's more planners that have touched this thing by far and given opinions. Also to the team, we have to recognize that it's police and code enforcement. They go out on a daily basis and have to use the code. Their input was very valuable in this case. We need to recognize the city attorney's office for sure. You know, our primary goal is to make sure that we're getting compliance with the Supreme Court decision. And then also on the engineering side, you know, safety issues, concerns, durability, and things that they need to look at. So our building and site development folks have chimed in as well. So let's kind of take a step back and let's talk about the code itself. The new code framework, there's 4 categories basically. There's prohibited signs. There's authorized signs, all districts, no permit. Now you'll find some of the government speech in there, the traffic signs, you know, are the typical government-associated signs within there, and some others. The 2 main ones that people most look at are the permanent sign types and the temporary sign types. So, permanent sign types, what do we mean by that? We're looking at signs based on durability. So we're looking at something that could be mounted to the wall, canopy, could be a freestanding monument. They're not going away anytime soon, so we call them permanent sign types. In your draft or your draft code that's in the packet, that will be in the packet and being adjusted slightly, there are 3 tables that you need to look at. Table 1 for building signs. 2 is for the freestanding monumentation signs. You'll mostly see those in commercial shopping center and freeway signs in there. Table 3 for other sign types. Also associated with that, you need to look at general provisions. And the reason why is because when we get creative with sign types, you need to know how to calculate sign area. You'll find how to calculate sign area. And if it's a multi-faced sign type, that shows you how to do the calculation in there as well. So we've got 3 tables and general provisions that you need to look at. On the temporary side, don't let it fool you. There's only one table, but it's a pretty large table in there. These handle the yard signs, the A-frames, the for sales, the election signs, the sign walkers, and everything in between are undeveloped signs. So while it is just one table, it is a comprehensive list of all the items that definitely can like pick up and go within a certain time frame. So those are the 4 categories that you see within the code. Now, I like to show these off because we've made some improvements. What we are doing will be doing is putting together a packet. We've had to reclassify sign types based on the Reed case. And so the names are not the same, and we want to make it easier for people to understand. What you normally knew was this, it will be this now. So the signs have been reclassified. The words, we are about at a 56% reduction on that. We're using the tables to do the heavy lifting on this one. Pages, from 48 pages, we're down to 22. And we've decreased sign types from 33 to 29 to make it easier to go through. Added bonus, we have reduced the number of areas where you need a permit. So it's easier for businesses and so forth to go through the process much faster. So we've looked at the process as well. And to increase the aesthetic ability, we have 2 new sign types, one of which that people are most excited about are the blade signs or projecting signs. We currently do not allow those within the city. We are allowing those going forward within this code. Which part, ma'am? So the new sign types, projecting signs, are now being allowed within the city, based with what we have in the code. Stakeholder outreach. Go through a couple of items. It's not necessarily representative of all the legwork that has been done, so I'll kind of embellish on it, if you will. So when we started this process back in 2016, we looked at the number of permits issued, which was about 400. And based on that, we identified industry representatives and sign companies and normal stakeholders associated with working on the code day in and day out. So we had over 70 representatives that we invited to the table. We had 2 meetings with those stakeholders, and the communication didn't stop from there. We also went out to 2 local groups and think tanks twice. And if individual meetings or people walked up to the counter, we would have conversations about the draft code as well. So we've received emails, phone calls, meetings, you name it, from that list. It's been a very iterative process from start to finish from 2016 forward. Because of that feedback and that outreach, we have received information from local and national groups. In addition, I made the comment earlier, we've had 3 previous planning and zoning study sessions on this. Congratulations, you are now the 4th on this one. We've also had 3 city council study sessions along the way. Like I said, interaction has been email, website. We've also posted it on website. We've had meetings in the newspaper and walk-ins. So what we're looking at after tonight is going forward for, hoping for a recommendation on the February 1st P&Z Commission meeting. We would like to take this to the March 6th City Council for adoption. Possible adoption. So now this is the part where I get to illustrate some of our refinements and ask for some feedback. Since the September last meeting through the Planning and Zoning Commission, it was September 7th, if I remember correctly, we've made a modification to vehicle signs. The intent that we tried to express in the September language was that the regulations, if you were using the vehicle in a normal daily business and you're moving it here and there, that regulation didn't apply. Based on feedback that we heard, the WEMAR asked for some clarity in that regard, and so we have reformatted and restructured the language to identify it's the stationary vehicles being used as permanent signs that we are prohibiting at that point in time. And by that, the code enforcement officers will determine if a vehicle is moving or not based on going behind the tires, and will mark it after a duration. If it hasn't moved in that long, then it's considered stationary. If you're there to go pick up coffee or whatever, those are not the type of company vehicles that we're trying to target with this one. Also, we have removed the limitation in terms of where a company vehicle can park. If for some reason you need the last parking spaces adjacent to the roadway, we don't really mind where you park. You know, you're moving it. That's not the intent here. What we're looking for is to target stationary vehicles being used as permanent signage on a regular basis. For instance, the one in the picture that is shown up above. Undeveloped property signs. This one is a slight change, not necessarily a major change, if you will. What you see in the red is where the modification occurs. So basically, it's the same minimum 100-foot separation between the signs. If it's greater than, if that sign next to it is 6 square feet in size. So if the next one is 6 square feet in size, then there needs to be 100-foot separation. We've also, to add clarity, to reinforce, we want to have a safety visibility triangle maintained between driveways and intersections. So that's where the 30-foot away from those driveways and intersections come into play. So that one's a safety feature. So that one's pretty minor. New subdivision sign. In September, this was in the packet, but we didn't address it at the meeting, so I just wanted to provide an update on this one. We clarified the information within the table. We tried to do our best. We've been shifting around a couple things here and there, and so one of the efforts between the last September meeting to now is to make sure the table and the information being presented was as clear to read as possible. So that's what we fixed. I also did want to point out that the Home Builders Association of Central Arizona provided a letter of support based on our recommendations to the code on these provisions in particular. And so that will be provided in the packet for February 1st as well. So this one's resident roadway signs. It's highlighted in yellow because it's the new name. Most people, layman terms, they don't understand what right-of-way is, but they will know what a roadway is. So we've changed it to resident roadway signs. Based on conversation with WEMAR, we have a better understanding about industry practices. So we've made modifications to the timing on this one. Now what we're saying, instead of 4 times a year, we're saying the sign can be out 3 hours before an event and removed 3 hours after the event. Typically, you would use this for your open houses or yard signs or something that you would put out adjacent to the roadway. So it's a little bit more in practice with, you know, you've got some time to get the sign out for visibility, and then after the event, you've got enough time to go out and pick it up and take it back in. We have doubled the number of signs allowed in this instance, from 4 to 8 per instance. We are also going back and including a reduced radius, if you will, but from 2 on the current code to a 1-mile radius around the property. So these signs need to be kept within a mile radius of the property that the event is being held at. Now I have a star on here where it says 8. In the conversation with WEMAR, other municipalities may have an additional quantity. And so as we're talking through and trying to figure out balancing the needs of the residents where these signs are going to be adjacent to and the rights of the property owner that may be using these signs, We thought doubling the quantity would be appropriate in order to have the number of signs from like the major arterial to the number of turning movements that you would need. So we thought 8 would get you there from like the major corners into the property. We also think there's room for improvement, that the city can kind of think outside the box and provide more information online to future, existing, and prospective residents to alert them to where our master plan communities are and our major subdivisions are. So instead of putting additional signs on the ground, maybe we get them closer to the starting point to begin with. So we didn't have consensus in talking to the industry with regard to the number of signs. That being said, we believe 8 is an appropriate number in this instance. We believe that other measures, maybe instead of putting additional signage, we can get there. I also did want to point out in this regard, this is a major rewrite, and so we're intending to go back after the code is in effect to see how it's working, and to go back out to the industry leaders and the stakeholders, get their feedback. So we may have additional refinements going on. But we think this is a good basis for going forward with the 8 per instance. Are there any questions on that one?
Any questions?
Okay.
Commissioner Condi?
All right, I'm looking at it, and it says 4 times per year, and 3 hours before the event, and you have an open house. Now, if you were a realtor and you had an open house, would that mean the 4 times per year is that specific property open house, or would that be an open house sign that only a realtor could put out have 4 open houses a year? That's one question I have, because I'm looking at the 3 hours before the event and 3 hours after. Most realtors put them out an hour before at most and an hour after, so I don't think that's an issue. But sometimes houses don't sell, and sometimes they will have open houses, for 5 or 6 for that same house. And so I think that is confusing. And that also goes down to 8 per instance, and then it depends on where the property is located. This 1 mile radius of property within residential roads, sometimes, depending if you're going north and there's big distances, it's hard to do that. I mean, you're not getting the activity if you're going from, you might want to put one on Union Hills and then one on Beardsley and then direct them, that kind of thing. So I think this is confusing.
A point of clarification, ma'am. So what you see on the left is the current existing regulation. What is in the middle column is what we had proposed as the draft regulations within the September 2017 provided to Commission. So going forward, basically what you see in that middle column goes away. We are recommending now what is on the far right-hand column. So it will not be 4 times a year. The standard for the timing would be however number of events the realtor or whoever else would like to have an event. The timing is simply 3 hours before the event and 3 hours after the event.
Like a garage sale?
Like a garage sale,
Okay.
yard sale, yes. So there is not a max per year anymore. It's just 3 hours before the event and 3 times, or 3 hours after. With regard to the number, we appreciate it and heard the same. We appreciate the feedback, and those are similar comments that WEMAR representative had provided to us. Now, and again, this is where we were suggesting to think outside the box. The example that I gave at the time was Vistancia. I looked at the website to see what was being offered at the time, and I kind of lowered the number. But if you chose 50 homes for sale in Vistancia, and Vistancia is a large master plan community, I can appreciate that it's a very curvilinear street and whatever. So if you had 50 homes for sale, and each realtor had an open house that weekend, 8 signs apiece, we would have 400 signs all along probably Vistancia Boulevard and various other locations. I'm not sure that is the most appropriate or effective use to get the individual there. I think there's other opportunities, and we had looked at identifying and providing information like maps or something to get people into locations better. That way the realtors can offer that map and it gets them into a better starting point. That way they could better utilize the signage that they are allotted to get them closer on the turning movements to where they needed to go. And I'm just going to let Chris chime in on that one.
Sure, Mr. Chairman, Commissioner Condi. If I can add to that too, and speaking with the representative from Weimar, whereas we did not have consensus on the number, the Weimar representative preferred to have an unrestricted number of signs, but basically a sign that can be accomplished for each turning movement to the site. However, there wasn't a problem stated with the signs being within 1 mile. The representative remarked that was reasonable.
Okay. One of the things I have seen looking at it is that sometimes, first of all, the idea of having 400 open houses is probably never going to happen. But what happens is that there will be some companies that will put up 4 signs at one intersection, and that gets very cluttered. And I can see that limiting it to 1 sign per, or 2 signs, 1 sign per corner rather than 4 or 5 signs per corner. And I've seen that happen. You don't need to have a march of signs every 20 feet. It is very distracting. The other thing is that this is hard to enforce because of, how is enforcement going to be for 8 per instance, or 3 hours before? You put some, to have something in a code, it's going to have to be enforceable. How is that going to be handled?
Mr. Chairman, Commissioner Condi, we're not, I don't want to say the sign place on this one, but we're not actively going to go out on an individual basis each weekend and kind of target neighborhood signs like this. The goal is we want to reward the good actors doing good things. We want to set parameters for the bad actors not following the rules. And so this isn't, if we see a continued a recurrence and somebody starts complaining, code enforcement operates on a complaint basis. So if we receive a complaint, that's when we're going to go out and start taking action at that point in time.
Okay. It's just to have a policy in place so that if there is abuse, you can do something about it.
Yes, ma'am.
Correct? Is that it? Okay. Thank you.
Okay, Commissioner Alsop.
Thank you. To me, a major point that hasn't been discussed, and I'm sure the realtors have a lot of concern about this. I'm sure Home Builders Association has a lot of concerns about this, and I see the bootlegs out there. And that is one of my questions, and maybe you've addressed it and I missed it. I am curious how this applies to home builder bootlegs, but also, in my opinion, this all revolves around the public use or right-of-way, which is, in my opinion, not a public entitlement. And so people are using them, and that's fine by me, but the access to that is not unlimited. And so I think it is well within the city's right to regulate that. Enforceability is a concern to me, but this is city property that we're allowing people to advertise their businesses on. And there's concerns about what if every business wants to come out and advertise at the same time. Then we've got a real problem. And that's never been a problem as far as I know. But I would like to remind the public that we're talking about use of city property. This is not private property we're discussing here.
Okay. Commissioner Antluski.
Yeah, just a quick couple things to think about. And I dislike the idea of what we called mega open houses, where there was 40 to 60 signs spread along behind my office in Surprise on Young Street. They're just everywhere. But the 8 seems to be good enough for some cases, But as I'm looking at 125th Drive in Vistancia, you'd probably want to bring both Lone Mountain and Vistancia Boulevard to that house. And just coming up Sunrise and Ridgeway and the maze that we create in our master plan communities, sometimes 8 isn't going to be enough. And I know the statement of we're not going to necessarily police it on an every week basis unless we get a complaint, it still puts the realtors in a bad light that they are breaking the rule if they need that 9th one. So it's just a concern that I would have and a suggestion. And I think I go back to, kind of what Liz probably said, something to the extent of no more than one at corner needed to direct at each turn, which is what Surprise is actually starting to come around to. You probably in 90% of the time don't need more than 8 to get somebody to a house. I can think of Trilogy back in the far west corner. Once you get them through the gate, you've got a lot of turns in that back west area. So I would just consider if there's a way to write that, something that's a little more broad. I mean, even 10 would probably be something a little more usable for some of these areas. And like I say, we're talking 5% of Peoria that this would be a problem. But if you work those areas, it's a problem. As far as taking, you got other realtors doing open houses, the concern I would have is if a realtor A is doing 11 to 1 and there's realtor B doing 12 to 2 and I want to do 1 to 3, what signs are still up at 1:30 that other realtors A and B had and took down, and now am I sitting in a house that has no traffic because they can't find me? So that would be, when we talk about the number of signs, we hope we don't see 20 on a corner. But as I drive through Trilogy, I see corners that have 5 or 6 signs because there's a lot of open houses. So I'm not sure how that plays into it, how we regulate that, but that would be a concern. And then, like I say, just that 1 per turn seems to kind of stand out in my mind, because that's how realtors do it, is they start here and go there and go there, and hopefully they get private property owners' permission to put it there. And
Mr. Chair, Commissioner Alewski, great question. Again, this is a part in the proposed code where we do not have a consensus with WEMAR on, and so perhaps this is a good time to take the pulse of the commission. Should it be 8 within 1 mile? And again, the WEMAR representative was okay with 1 mile being the distance, or is it the number of signs based on unrestricted, but based on however many turning movements to get to the site, or is it some other number? I'd certainly love to hear from the rest of the commission on that.
Well, we don't have any commissioners that wish to speak right now, so that's what you get. Oh, now the light's up. For myself, I mean, I'm not in the industry, and the signs, unless I'm not also not in the market of shopping for a house, and I've really, personally, I don't take issue with these signs because they're pretty harmless. They're temporary, and they're typically out on the weekends and gone during the week. They really don't impact my life, and if it impacts, somebody that's trying to sell a house or somebody, whether it's the homeowner or the business, I'm not opposed to extra signs if that's what the industry says they need. We have a few commissioners now. Commissioner Albright?
Yes, I think that Lori touched on the fact that we're not going to go out as a police force and make people take down signs if they're up for a legitimate reason, and we're just not going to go out and do that. We don't probably have the people to do it anyways. If there is a complaint that comes in or a request for a particular usage of a number of signs, that may be something that someone can, we may put a back door in to permit that through staff somehow, or a temporary use type of permit that says, I need 10 signs and I need them for the next 6 weeks. Can I get a permit for that? And maybe that's a way to give us a back door to get to that, without making it an absolute stipulation or opening it up to signs everywhere.
Well, we don't have any commissioners that wish to speak right now, so they, that's what you get. Oh, now the light's up. Commissioner Albright?
Yes, I think that Lori touched on the fact that we're not going to go out as a police force and make people take down signs if they're up for a legitimate reason, and we're just not going to go out and do that. We don't have probably have the people to do it anyways. If there is a complaint that comes in or a request for a particular usage of a number of signs, that may be something that someone can, we may put a back door in to permit that through staff somehow, or a temporary use type of permit that says, I need 10 signs and I need them for the next 6 weeks. Can I get a permit for that? And maybe that's a way to give us a back door to get to that.
Would you guys like to respond to that?
I'll throw it out. Let me throw this out for consideration, because these signs, if I recall correctly, let me peer on my code, we do not require a permit now. So it would be an additional step based on the Realtor to come in. What I would suggest, what has been suggested is that maybe the planning manager make that call at that point in time. So we have a staff approval, if you will, that they can come in, fill out the information, and hopefully cut down the time. So yes, they could ask for the additional signage for a certain period of time. So if you will, like a mini TUP, without having to go through the full process. Is that something that would be appropriate?
Mr. Chair, Commissioner Albright, just a quick thought we had was perhaps, we have the number 8, but to the extent we had one of those property situations where more than 8 signs was necessary, given its location, it could be perhaps that's, the planning manager on a case-by-case basis perhaps is able to, some mechanism to approve additional signs for that instance. Maybe that's one way to look at it.
It may not become an issue ever, but if someone does come in and say, there are 10 signs or there are 12 signs, then that may be the time for something to be done. Or it could be that they want to go outside the code and they want to come in advance and make sure that happens. And it doesn't open the whole, the whole community up to having, having us to have to decide that we want to have more signs for everybody. They can be an annoyance, I guess.
Just an additional comment. So when we met with the Weimar representative remarked that 8 signs would satisfy, I think, 80% of the situations is what she identified. But I think for those 20 or for those hard-to-reach sites, that's why she recommended that, it's okay to have the signs reined in within a mile, but it could be a lot of turning movements to get to the site, and that's why they were recommending unrestricted. So that's an option, too, to have the number of signs based on the number of turning movements to get to the site, but all have to be within a mile.
All right, we have a couple more questions, and while we're addressing the commissioners' questions, because I know we have several on the board, I think, that are in the real estate business, I believe, I'm pretty sure. If in your commentary you could educate me a little bit on this particular case, are these signs, do they work? Are they, does a customer looking for a house drive down the road and say, open house, I'm going to go that way, and then follow these signs to random houses that are for sale? Or is it driven from the realtor saying, oh, my signs are out, follow them from this point, and then look for the red and white sign. I don't know how these work. It just they seem to be, I don't know, it doesn't seem like a very effective way to do it. And if somebody wants that Fistancia house sold, but they're trying to get somebody come from the 101 down Union Hills and up Lake Pleasant Parkway and all, how many signs does it take to get them up to Lake Pleasant? Okay. That's my curiosity is getting the better of me right now. Commissioner Condi.
Well, the signs work, which is why we use them, because there are people, especially during, this is the high season, that you fall in love with an area and they go, oh, let's start looking at houses. And they look for the open house signs, and they go and they visit it and they buy. My mother did that. And I sold a house, a month ago with somebody just driving around and went, oh, this is just, so they do work, that's one. 2, I think that it really depends. Sometimes 4 signs are enough, 6 signs are enough because you have straight streets, it's easy. In other cases, you almost need 2 per intersection. 1 for the people going one way, 1 for the people going another way to tell them which way to turn. So I like the idea of 2 signs per intersections, 2 directional signs per intersections to a maximum of whatever is needed to get there, because there's some places, like you mentioned, Vistancia, Trilogy, are incredibly curvy to get to. And then there's some, it's put a sign on the corner of Thunderbird and 91st, turn right, go down, turn right into 4 signs will work. So it really is dependent upon where the property is located and how difficult it is to get there. but they do work, they're temporary. The agents will usually take them down within leaving the house because they don't want people going and not being there too. So it's you don't put out a sign. Garage signs, sales, you put out 3 hours earlier or 4 hours, but open house signs, no. And maybe there should be 2 different ones, one for specifically geared to realtors and one for everyone else. Because there are people perhaps that have businesses that use those signs, directional. And that was a problem, I believe, that the city of Surprise ran into. You have people that are tucked back into an area and they use those temporary signs when they're open for business to get people there. So anyway, those are my thoughts.
Okay.
Chairman,
Commissioner
Commissioner Condi, I appreciate the suggestion. However, that would not be READ compliant. We would not be able to make the distinction between a yard sign and that somebody's using or a real estate sign. So we're having to do a one-size-fits-all, if you would. Thank you.
Okay, Commissioner Alsop.
Yeah, I know I'm probably not making any friends with realtors here. Again, Chris asked, he solicited our opinion on, number of signs, and in my opinion, the less the better. And so I'll publicly state that, and the reason that I say that is reemphasizing we're talking about public property. You want to put a dozen signs on your neighbor's front yard and they give you permission to, fantastic. But we're talking about public property, and I really see this going down the road of, what about me? What about me? Every other business in Peoria now wants their fair share of signs. And I don't like the idea of us discussing what is the right number of signs for every business inside the city of Peoria. So I'm uncomfortable with the discussion. And for that reason, I know there are cities that have no signs, the city of Henderson, and business still goes on. Not a lot of people are going to like that suggestion, but that's my opinion. And if you're going to ask what our opinions are, that's mine. I recognize that's probably not going to happen here, but that's where I stand, and I'm comfortable with that position.
Chairman and Commissioner Alsop, thank you for that input. One clarification that you won't see in the sign code. We do make a distinction between residential and commercial signs. So commercial signage is commercial speech, the bandit signs, if you would, those are prohibited. So the signage that you should be seeing in the right-of-way would solely be residential signage, those for yard sales. So a resident of Peoria or their agent would be providing those signs out in the right-of-way. So yes, the commercial signs you shouldn't be seeing, those are the ones that our sign code guys like to go out and pick up, if you will.
Okay, we have no other comments from the commission. We want to move on. We have so many more signs to talk about, I think, don't we?
I have one more,
Okay.
but if I can, I think maybe in a quick show of hands, how many commissioners would be in support of the 8 on the number of signs, just so that we can kind of take a quick pulse, are okay with 8 signs per instance? I see 1, 2, 3, 4, 5. Okay, 6, is it 5 or 5? 1, 2, 3, 4,
Yeah.
5, 6, okay. On the number of signs, I'm taking a quick poll. Is 8 the appropriate number? And so I see a show of hands of 6 people. That would be the starting.
What are other choices?
Okay, the other choices would be 10. Okay. This is not an auction. We're not necessarily. No, I'm kidding. The other option we've talked about is a sign for every turning movement within the 1 mile radius. So A, B, or C. You get to choose one. So A would be.
I'm sorry, can you repeat the last one? I wasn't
Sure.
clear on that one again.
So you would be able to have one sign for every turning movement
Okay.
from 1 mile radius around the subject property. So there wouldn't be a quantity, it would just be based on the number of turning movements. So option A would be 8. Option B would be 10. Option C that we've talked about is, sorry, I forgot option D. So Option A is 8. Option B is 10. Option C is turning movement. Every turning movement, one sign for every turning movement in a 1 mile radius. Option D, as Commissioner Albright proposed, is but if needed, and get a special approval at
So
that
there'd be an
point in time.
administrative remedy of some sort. They could come to the city, is that what I'm hearing? And talk to staff, and staff could grant an exemption based on their circumstance? I want to make sure I understand that.
I guess my thought is that if, a lot of this is driven by bad actors, people that don't follow the
Without
rules
question.
in the first place. So my proposal is that we would have 8 signs. People would use their judgment and use more. I mean, they're going to do it anyways. If a complaint comes into the city, that person has to get approval to have more signs. Or the person would come in advance if they want to be a good player and get approval for those signs. So,
Reasonable.
I guess it's kind of like there's going to be rule breakers, and we have to accept it. But
So for clarity's standpoint, I
thank
think talking from staff, that may be kind of difficult and arbitrary to do. So let's limit it to 3 options, if you will. So for those who think 8 would be appropriate, can I see a show of hands? I have 1, 2, maybe 3
My hand's
going.
halfway up. I'm not quite ready. Before we take a poll, though, Commissioner Patterson would like to have a word.
Yeah, thank you, Mr. Chairman. Well, since this is done on a complaint basis, typically, can you put language in there that gives the planning manager the authority to waive the 8? If somebody came in, they got a complaint, they come in and say, well, I had 10, but here's the reason why, then you could waive the requirement for that case.
Mr. Chair, Commissioner Patterson, so it's always problematic to throw out an idea on the fly, which I did a few minutes ago. But upon thinking about it the last few minutes, if we had a standard and then allowed the planning manager to make a waiver, there's always the next question of what criteria. Because what we want to do is avoid arbitrary situations and get into this where we're allowing somebody 14 and somebody 12, and how do you distinguish between that? So we want to avoid arbitrary judgments, and I think that might be difficult to do and put a lot of onus on the planning manager.
Commissioner Alsop, also.
Yeah, I was going to say the exact same thing. I think that would bog down Adam. Adam's like, I don't want to have to do that every time. And I think that amounts effectively to none being done, because honestly, I'd be shocked if any realtor says, hey, Mr. Planning Manager, can I get 16? Yeah, and I think that's just tantamount to just saying it's not going to happen, and it creates a real problem for staff in enforcing and making those decisions without putting themselves in a situation where they might have to legally think about what's the best thing to do.
Okay, we don't have any other commissioners that would like to vote. So if you could go through what do we have now, 4 or 5 choices? We have 3, okay.
Okay,
If
so
we
one
could
more
get-
time, we have 3. So option A, 8 signs. So I see 1.
Can you say the choices again?
Okay, option A is 8 signs.
Okay.
Option B, 10 signs. Option C is 1 sign for every turning movement within a 1 mile radius from the property.
Okay.
Okay, so is every,
4, or you could have 10.
so 8, 10, or every turning movement within a 1 mile radius, okay?
Okay.
Okay.
We'll go with, let's
So-
poll.
Poll, it seems to be easier. Option A, 8 signs. I have 1, I have 2. Okay. 10. I see a clear winner on this one. We have 0 for that one. So for those, 1 sign, every turning movement within a 1 mile radius. I see 1, 2, 3, 4, 5. All right, thank you. We will make that change, and you will see that in the packet at the February 1st. So that was a long process, but we only have 1 more sign type one more change. So we're going to be picking up steam here.
Before we move to the next sign type, Commissioner Outluski.
Yeah, and just a quick comment on that. That actually helps with the issue of too many signs, because if you're 71st in Peoria and you're one block in, you're using 2 signs. If you're in the middle of Trilogy, you might have 7. Now you don't have an agent that says, oh, 10, great, I'll put 3 here and 2 there, and it actually creates a case where you have 2 or 3, or you have 10, 11. Very seldom are you ever going to get 14, 15 turns to any house. But I think it's the easiest to both for code enforcement and to give, realtors their option to get people to an open house.
Okay, Commissioner Nelson?
My only reservation would be, and I still like the option, but is it too complex for a resident to understand this? How do we interpret this in a way they're clearly going to understand how many signs they can put up based on where they live? That's my only concern. If we feel we can interpret that in a clear, articulate that in a clear way, I think it'd be great. But that's in the back of my mind, is that concern. We're talking about turning radiuses and things like that. We got to make that obviously easy to understand, but I'm sure you can do a great job with that.
Okay, we have no other comments from the commissioners. You can move on.
Okay. So the last one. Actually, I'm sorry. There's 2 more. This is one. I know. This one's pretty good. And we did have consensus on this one. So if we've changed, instead of saying property listed for sale, lease, or rent, the word listed implies that you are listing it with an agent. So we are changing the term offered, because for sale by owner, you're offering it for sale. So it's property offered for sale, lease, or rent. That was the suggestion, and we are making that modification. The additional suggestion is changing the quantity. For those properties that abut an arterial or a collector street, you would be able to have 1 additional sign placed in the backyard. The maximum sign area that we are proposing would be 4 square feet for that one. So you would still be allowed to have the sign in the front yard, but those properties backing up to pretty major thoroughfares could have a sign attached to the wall, or however mechanism you want to do it. So 1 additional sign, 4 square feet in the back, that would be visible from the street. Okay. The other consideration, and we agree with, we do have a number of additional housing types starting to come online. So for those townhomes or single-family homes, condos in particular, where you don't have a large front yard, the request has been, if it's a multi-story unit, instead of placing the sign in the front yard, you should be able to place it within a window. So we are in agreement with that. So if it's a multi-story unit, you would be able to place the sign in the window instead of the front yard. So same sign area, just location has moved to 2nd story up above or whatever. Timing. We have simplified the timing on this one. If the property is, you can have the sign up from the time that the property is being offered for sale until 10 days after the completion of the sale or lease transaction has occurred. So we've simplified it. No more option A, option B. It's just one thing. So we believe we have consensus on that, and you will be seeing that modification in your packet. Okay, last one, and this time, Scout's honor, it is the last one.
Sorry, can I just ask a question on the last one before we move on? On these signs, so if there's an HOA that restricts this or says you can't do that, which one does the homeowner obligated to follow? The city ordinance, or which trumps which? I'm not clear on that.
So the city sets the standards. The HOA can always go more restrictive.
More restrictive, so whatever the more restrictive rule is, wins that. Okay,
yes, if you are in the HOA and they are more restrictive, you have agreed to abide by their rules.
Okay, thank you.
Okay. Window signage. Currently, the standard that we are proposing is to maintain the existing one that is today, which is 25% of the total window area may be used as signage. We also are asking to prohibit it above ground floor. So if you are doing window signage, it needs to be on the ground floor. The industry request is potentially going up to 50% of that window, which the sign is placed, and providing no limitation. So it can be on the first floor, second floor, and continuing up above. This one, we're going to be asking for your opinion, and I will be providing a couple of thoughts and based on what staff is looking at. Something for consideration, and why we think 25% in keeping the same requirement should be considered. We've made a number of changes on a number of other signs, the signs that you have on to the right of the screen. We have increased the ability for a commercial user for monumentation signage. So now they can have larger monumentation signage out along the street. We have increased the size that you can have for building wall signage with this code proposal. We have increased the ability to have awning and/or canopy signage in this proposal. You can have an entry sign. We are now introducing a projecting sign or the blade signs underneath. We have added that to the mix that they can use. If it's a large commercial center, they have the ability to use an internal directional sign. If we don't see it from the right-of-way, we don't look at it. So they have the additional, if the center is large enough, they have the additional ability to use an internal directional sign to get to their business to the back of the center. They have window signage as a possibility. And then under additional temporary signs, we have increased the ability to have an A-frame for a business every day, doesn't matter, from a certain time, in and out, just needs to be within 8 feet of the building entrance. So if you're having a quick sale, you can put an A-frame out. We're not looking at it. If you are a grand opening or a new business, you have the opportunity to do banners and everything else associated with a grand opening in new business. If it is a special event and you want to do additional signage, you can do a special promotion. There's additional allowance for signage in that regard. So based on, from start to finish, all of the options that we have increased or options available to a commercial or a tenant, we believe we don't need to increase the size of the window signage at this point in time. Additionally, we also had the provision at 25% originally because of safety considerations. If you couldn't see in the window, then we had a concern with what's going on the inside. That's not necessarily 100% accurate because now we have window treatments that are kind of changing that in opacity. So we're trying to treat, the technology is changing in this regard, but we want to be able to have the building be the building and not necessarily detracting from the architecture of the center. So we want to maintain our design review manual standards, which says there needs to be some consistency with vernacular elements and design and everything else. So we think 25 is an appropriate percentage at that point in time. So that's our thoughts. I don't know if, Chris, you want to add anything? So we would like to hear what the commission has to say. Is 25% appropriate? Is 50% appropriate? Is there something in between? I would also add, if you go somewhere between 25 and 50%, it's hard to make a judgment call at that point in time. Because you can see a quarter, you can see a half, you may be able to see a third, but if you get it somewhere in between, it gets a little harder for our code enforcement guys to go out and start using tape measures. Not really a good thing. So with that, Chairman.
Okay, Commissioner Lewski.
Yeah, so in regards to the maximum sign area, I mean, 50% sounds like a lot. I'm trying to envision two buildings, one that might have windowage that's 40 feet wide, and a small one that might be 10 or 15 feet. I mean, that big window is going to have a huge sign even at 25, but then when you get small, you know, that 25 seems. So in your thinking of staying with 25, did you think that, like the size of the windows through?
Chairman, Commissioner Olszewski, just point of clarification, it's 25% per side. So if you have a larger window area and 25%, you can have that larger window at 25%. If you're on the adjacent side, you can still have additional signage on that side. So we didn't necessarily consider the size of the windows that we were looking at. It's a little bit more difficult at that point in time to make and it gets into a subjective call because then we're starting to go apples and oranges at that point.
Yeah, Chairman, Commissioner, really what we're looking for is the aggregate of the window space on any one elevation or any storefront, if you will, but there's some buildings that may have 3 frontage that are, they've got plenty of windows on all 3 sides. All 3 sides would get 25% with this. So it's not 25% just kind of shoved into one corner. It really is the aggregate.
Aggregate. Yeah, because 50% seemed really big. The question, I guess, on the limitations of none, I'm trying to picture in Peoria where we have a lot of businesses on a second or third story, or anywhere really. I'm trying to picture the need for a sign in a second story. So I'm not sure where to go with that one, but I'm not sure that we need to allow that. Has it been prohibited up till now? Mm-hmm. Yeah, that's a tough one, because like I say, I'm trying to picture what you might have up in the second story with businesses under it. And is this going to be, well, I guess the example would be a 2 or 3 story office building, and you're on the second story. Do you get signage in that window? Now, you'd have a wall sign permitted, correct? But the window, you wouldn't.
Chairman, Commissioner Olszewski, you are correct, and including, we've made the change on the building wall signage, that if you are a multi-story building, you have the building owner has the authority to designate where signage can occur. So it can go first floor, second floor, whatever. It can go horizontal, like a banding. It can go vertical if that's what they prefer. So the property owner sets where the signage should go for building wall signage at that point.
Okay, thank you.
Commissioner Alsop.
In this case, we're talking about private property, and in my opinion, less regulation is better. And I agree. I don't know where in Peoria people are going to want second story advertising, but I don't think it's necessary to make regulations on something just because it's unlikely. So to me, I would just say no regulation. But we're discussing private property, and in my opinion, I don't like the idea of restricting private property. I would like to do that as little as possible. And so in this case, if industry request is 50%, then I would be in support of that.
Okay, Joe, Commissioner Condi.
Yeah, okay, I'm looking at this picture, custom window decals, okay? And it has black and then it has the white lettering. Now, if that window were clear instead of black, do we consider the letters being 50% or 25% or the whole area that's covered being 100% because it's black behind? I guess my question is, many places just have, gold lettering on their windows or something. And is the lettering the 25%, or is it, how do you do that? I don't understand.
Commissioner Condi, it's a great question. This picture is difficult to make that distinction. It is black in this case. Normally it wouldn't be black, it would be see-through, but we didn't want to necessarily showcase all the advertisement, behind the scenes, so it's a black thing. So picture it as see-through. In the case of what we would determine for sign area, it is treated similar as you're talking about. We would look at the lettering at that point in time. When you start to get so dense in the imagery that it just becomes homogeneous, then we start boxing it in at that point in time. So in this case, we would be looking at the lettering.
So you'd look at the lettering and that covers maybe up to 50% of the window, but it wouldn't be necessarily offensive because, But then I agree, my question is, what if you have a small door or a small window, and then, you might need the 50%, whereas, a 6 by 8 foot window, 50% is huge. So is there, I think it's a real conundrum.
Commissioner Conti, if I can just add to your comment there. So the letters would be what's the calculated space, but all of the spaces now that are black, so you've got the large window, the door, the transom above the door, and then the side light, that's the aggregate window space. So all of that, it's 25% of all of that.
Got it, okay.
Yeah.
Thank you.
Commissioner Grice.
I would like some clarification about just what you're speaking of, whether it's the whole frontage that's available or just when I read the window area in which it's, the sign is placed, I think of one window. This custom windows decal example that we have here, that looks like to me it's just, that's what we're discussing, one pane and not the front.
Commissioner Grice, if we need to clarify that, we can. It would be the aggregate of the frontage.
And then could you just give me an estimate of what you think this coverage is on this example?
Without any dimensions, that'd be difficult to do, but I think you're probably right around 25%. If you were to kind of compress that into a space, measure the boxes, and then put those boxes kind of down in one corner, I would assume it's probably around 25%.
See, I would have guessed a lot closer to 10.
Okay. Yeah, it's when you start to box the letters and in the space, the boxes, you have 3 boxes there, one for custom, one for window, one for decals. So yeah, it's hard to know, but I would say it's 25% or less.
Thank you.
Okay, I think I hit the clear button. Was there any other comments from the commissioners? Commissioner Conti.
On the case here, then if you take the aggregate of all of the window space in front, then they could put the custom window decals in the big one, and they could have maybe on the door, if it went up to 50%, they could have the door that said hours, whatever it was, which would also be signage, right? And then it could be. So I could see why they could need 50% if they had something like this, because they might have to put something on the doors regarding their hours or whatever. Okay.
Chairman, Commissioner Condi, there is an address sign, so we wouldn't be looking at if it's address-related information that has its own category, that would be separate from this one. Primarily, we're just looking at the area as a whole, but we're looking at the windows themselves and not necessarily the information on the door at that point.
Just a comment about some of the conversation. So while I do agree that having government regulation over private businesses is not always favorable or desirable, I do, however, believe there is a place to have regulation when you have business A and business B right next to each other, and if business B is doing something to cause a distraction or cause commerce for business A right next door to create an unfair, whatever the case may be, having this in place, I'm in favor of this. I'm in favor of the signage and making sure that the signs are, they don't cause clutter. We have regulations in the city to make sure the city is overall a desirable place and to be and presentable, and that's the way we look at these things. And I do agree with that. But there is, to Commissioner Alsop's commentary, there is definitely a line, a very fine line to be crossed here. But I do agree with staff recommendation on the 50%, but limiting it to 50%. That's just my. I'm sorry, the 25%. Yeah. It's okay. Any further comments from the commission? I hit the clear button, and I don't know anybody else in the queue, so is there any other comments? Okay. And go ahead and continue.
As I promised, that was the last one.
Oh, great.
See, I did hold true to my word. But going back, just as a reminder, so we've made some comments today. Also, I believe I will offer it up. We do have an industry rep here if she would like to propose comments. Chairman? So is it?
We do have one more comment from the commission.
Just a quick
and
one.
then
We went through.
You can come on up.
Thank you, Chairman. If we can go back to the vehicular sign one, I think that's what it was called. I might have the name wrong. Vehicle sign. Sorry, we'd moved on before I had a chance to ask. A question I had raised it the last time we had this before us, and I'm not clear, I'm not feeling like it was addressed, and that was the question about stationary vehicles. So occasionally, as I'd mentioned, that you would come across where somebody would back a tractor trailer up, disengage from that, pull out, and there's a sign on the side of that tractor trailer. Is that stationary? Is that considered mobile? How is that dictated under this criteria?
Commissioner Nelson, that's a good question. Yes, we have clarified the language, and let me see if I can read from it real fast.
Thank you.
All right, so bear with me on this one.
I appreciate the fact it's been addressed. So. I can't wait to hear what it is.
It's about on, right now it's about on page 6 for vehicle signs. And we're suggesting vehicle signs are exempt if the vehicle is consistently used in a normal daily conduct of business, i.e. delivery and service vehicles. The vehicle shall be operable, properly licensed and parked in a lawful manner on the business property. And the intent of these regulations is to prohibit the use of vehicle signs as permanent freestanding signs in order to protect the aesthetic qualities of the city's built environment and promote the effectiveness of the building signs as provided in this section. Let me also add this piece because we have a definition of what a vehicle sign is in here. A vehicle sign is defined in our definitions that we're proposing is a sign that can be carried, towed, hauled, or driven, and is primarily designed to be mobile rather than limited to a fixed location, regardless of modifications that limit its mobility. So within your example, the trailer being parked with the sign, as long as that sign is moving, then that's fine. The moment that it's parked at a location in front of a business on a constant basis, does not move, it becomes stationary. It's a stationary vehicle sign at that point in time.
But if they used it occasionally for deliveries or for something, then they're okay? Is that okay?
Correct.
But they just
yes.
can't. It can't exist for the sole purpose of being a sign and just basically just sit there empty and not used.
Yes.
Okay. Thank you. I'm glad to see that was addressed. Appreciate that.
Okay, we have a member of the public, Susan Nicholson. Would you come on down to the podium? Bet you didn't think you have to wait this long, did you?
What's that?
Bet you didn't think you had to wait this long.
I was forewarned.
Okay, great.
Thank you, Chairman and members of the commission. My name is Susan Nicholson. I'm a Realtor with DPR Realty. I'm a member of WEMAR, and I sit on the Government Affairs Advisory Council. Liz regrets her inability to be here. She's discussing sign ordinances with the City of Surprise tonight. A few more thank yous while I'm at it to your amazing city planners. Thank you for taking the time to, I saw it briefly in Liz's office, this quick reference guide that your planners are planning to make available to the public at some point. When determining what is the right thing to do and the legal thing to do to be able to have that picture-y, lovely, quick reference guide is something that I, and I'm sure my colleagues would greatly appreciate. The modification of allowing us to have backyard signs over the wall is also something I would like to thank the planners for including. Those properties are stigmatized by being right up against those busier roadways, and the traffic that's generated from those over-the-wall signs are people that aren't bothered by that stigma. So for those property owners, that is something that I think is very, very important, and something that they would really appreciate your thought in putting that together. I have a couple of other thank yous that were actually items that I was going to moan and complain about earlier, but now post this meeting. The kind of consensus of allowing us to have a directional sign everywhere where a person has to turn their vehicle. I'm grateful that that is the decision, because I know my colleagues and I know how this would work. I know that if you gave us a set number of 8 or 10, if the house in a 1-mile radius, if the house was in the front of the subdivision, there would be 4 signs coming up to that subdivision because they only need 2 within. They're going to use their 8 that are allotted, and you're going to have more clutter and more signage than that's necessary because they're going to use what you told them they could have. Whereas really cleaning it up to say what is necessary in order to get the traffic to your house is great. And the option of coming in and getting a special use permit, I hate the idea of my competition that's 2 blocks further up closer in the neighborhood being able to violate me because I needed to use 10 open house signs. And most real estate agents wouldn't probably have, even in all fairness and honesty, have read the code to know the difference in the first place. So thank you for that discussion and being friendly to our industry, and that consideration is amazing. I had one comment about the property rights in Table 4 temporary sign where it said it was listed, and you guys have now changed that to offered for sale. That's something that's not necessarily beneficial to me as a realtor, because listed obviously means listed with a broker, but it's important to me as a citizen because for sale by owners should have the same rights that I do as a realtor to represent and market their properties. So thank you for that. I had read in the proposed code that open houses are listed as weekend events, and I'd like the consideration that open houses really can be 7 days a week. And when we do Wednesday, Thursday, brokers opens, and those type of events, usually it's for our most distressed homeowners who have a foreclosure that they're possibly facing, or they know they can only make a few more payments, and there's nothing that turns the hustle on to their listing agent more than knowing there's a deadline. And so in those instances, we often do hold open houses on Monday, Tuesday, Wednesday, Thursday. Every day that we can, we'll have other agents covering because we need maximum exposure in every avenue that we have available to us. I'd like to, and I don't have the solution for this, but I do know that like Lake Pleasant Estates is coming up, and it's 6,500 homes, and it's way out there north of Estancia, I want to say. And homeowners don't always live in their house for 5 or 7 years before they have to sell. Some people buy and they get relocated, or they get divorced, or there's a death and they can't afford the mortgage without their spouse's income. And as a practitioner, I wonder, how do I get traffic up there? Is there a way the city can help us to say, hey, there's a development of 6,500 homes up here? Vistancia has been around, kind of long enough. People know that Vistancia is kind of there. People don't think there's anything up beyond Vistancia. I guess there's Cowtown. Learned that tonight. So anyway, but so just kind of a food for thought. I don't know if there's a way, I guess it would be access to public right-of-way possibly, and the allowance because of the density of homes between the subdivision and the areas where there is traffic, to allow realtors the ability to say every quarter of a mile place a sign that says, yeah, keep going, or every half a mile until you get to within a mile of the subdivision. And I don't know how that's measurable or enforceable, but food for thought. And when I had read through it, and this may have been changed too because Liz and I talked about it, I read, and it was sort of article was used and code was used and section was used, and I found myself flipping through pages going, wait, what article, what code? And so the previous version seemed to stick more to the code and sections, and I felt that that was a lot easier for me to flip and follow through. Other than that, that was it. Thank you for your time this evening.
Thank you for your comments. Okay, I have no requests to speak. I don't have any other,
So, Chairman?
oh, Lori's requesting. Okay.
So yes, let me, Susan made some great comments, and so let me quickly respond back on a couple of different things. Previously on the resident roadway signage, we had a duration that we were proposing from Friday to Sunday and holidays. That is no longer applicable. What you're going to see in the February 1st packet is that duration is 3 hours before the event and 3 hours after the event. So that it's no longer a day specific, it is just time specific based on, so you can have it Monday through Friday, weekends included, it's up to you, it's whenever the event is. In terms of article and section, yes, I have, word is my friend right now on the program. We have gone through and taken out the word article. It is a section now. We've also made a reference, easier reference to talk about sign code. So instead of article and section, code, et cetera, there's two things you need to remember, and we've capitalized it. It's a section. If it's a capital section, it's based on the sign code, or we say sign code. Those are the only two things. We don't say code, we say sign code, or we say the section, meaning the sign code section. So we've clarified those references. Those are great comments, and we've already incorporated it. So yes, it's an iterative process. You'll see a brand new draft next time.
Excellent. And we should expect to see this on the agenda, the regular agenda for the next meeting. Okay. No other comments from the commissioners? Okay. We will move on. The next item on the agenda is called to the public for non-agenda items. Seeing no requests to speak, we will move on to updates from staff.
Mr. Chair, members of the commission, just two items tonight. On the screen, you can see when the next meetings, we have meetings scheduled for both the 1st and 15th of February. The second item, I wanted to address a question that we had at the last meeting. A commissioner asked about the zoning text amendment that we had brought to the commission pertaining to mobile vendors or food trucks. And I just wanted to mention that at the conclusion of the study session that we had with the commission, staff has gone back and reviewed it. We've been assessing it. However, very recently, a bill was dropped with the legislature about food trucks and mobile vendors. So we are participating in that review. We've paused our further assessment of the food truck text amendment pending the outcome of that bill, because we don't want to make a change or suggest a change and then the legislature changes that and we have to then go back and change our code again. So we're going to watch that amendment and see how it turns out. We'll report back to the commission.
Okay. Okay, great. Do we have any updates or reports from the Planning and Zoning Commission on current events? Commissioner Nelson.
I just wanted to apologize to the commission for being late tonight. I had a flight that came in quite a bit later than I expected, so my apologies for showing up late.
Well, try better next time.
I will.
Okay, seeing no other requests to speak, we are going to call this meeting adjourned. Thank you all.